Clarence Earl Gideon was a frail, poorly educated 51-year-old ex-convict who had served 4 sentences for gambling and theft. One day he was arrested for allegedly breaking into the Bay Harbor pool room in Panama City, Florida. This was based off a witness's story. Unable to afford a lawyer, Gideon asked for one. The court replied with, quote, "Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case," end quote. Citing Betts v. Brady, saying that since the case did not involve capital punishment, counsel was not to be provided by the court.
Describe what you saw in more detail.
So there I was, standing outside the pool hall, when I saw somebody suspiciously coming out with a bottle of wine in hand. I watched him for a little bit and noticed it was none other than Clarence Earl Gideon. He was acting very strange. He walked over to the payphone where he made a phone call for about 10 seconds or so. Then he sat on the stairs of the pool hall. Shortly later, a cab pulled up, and Gideon got in and left.
Thank you, Mr. Cook.
The witness, Henry Cook, was then cross-examined by Gideon himself. Gideon failed to question Cook's stories. Gideon then called up 8 witnesses for himself, but was still handed a guilty verdict by the jury. The whole trial lasted less than a day. At the sentencing hearing 3 weeks later, Judge McCreary sentenced Gideon to the maximum sentence of 5 years in prison.
From his prison cell at Florida State Prison, making use of prison library and writing in pencil on prison stationery, Gideon appealed to the Supreme Court of Florida. He wrote the following letter to the court.
I, Clarence Earl Gideon, informs this court that I am a pauper, without funds or any possibility of obtaining financial aid, and I beg of this court to listen and act upon my plea. On the 3rd day of June, 1961 AD, I was arrested and charged with the crime of breaking and entering with the intent to commit a misdemeanor, to wit, petty larceny, and that I pled not guilty to this charge. That on the 4th day of August, 1961 AD, I was tried in court of Bay County, the 14th District Court in and for the state of Florida, and was found guilty as charged. That on the 25th day of August, 1961 AD, I was sentenced to a term of 5 years in the state prison. I, Clarence Earl Gideon, will show this court that I did not have a fair trial, and was denied my constitutional rights that's guaranteed by the Constitution and the Bill of Rights by the United States government. I was without funds and without an attorney. I asked this court to appoint me an attorney, but they denied me that right. I told this court of the 14th District of Florida, County of Bay, the United States Supreme Court of the United States of America had ruled that the state of Florida should see that even one who is tried for a felony charge should have legal counsel. But the court ignored this plea. I, Clarence Earl Gideon, claim that I was denied the rights of the 4th, 5th, and 14th Amendments of the Bill of Rights. I, Clarence Earl Gideon, beg of this court to issue a writ of habeas corpus and to set aside the 5-year sentence that I have by the Court of Bay County, 14th District in and for the state of Florida, and to give me the aid that I need. Signed, Clarence Earl Gideon.
When this application was denied, Gideon handwrote a 5-page appeal of this denial to the United States Supreme Court.
Each year, the United States Supreme Court receives thousands of petitions. Most are rejected without any hearing. Against the odds, the Supreme Court decided to hear Gideon's petition. The case was heard as Gideon v. Wainwright, the director of Florida's Division of Corrections. After review of the case, Justice Hugo Black delivered that the court's opinion stating that the first ruling of Betts v. Brady be repealed on the grounds that it was unconstitutional because it denied the constitutional right to counsel. Black also cited that the 6th, 5th, and 14th Amendments concluded that a common man, quote, lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. End quote. Concurring opinions from Clark, Douglas, and Harlan added that
the Constitution makes no distinction between capital and non-capital cases.
Rights are protected against state invasion by the Due Process Clause of the 14th Amendment.
The right to counsel should now be expressly recognized as a fundamental right embraced in the 14th Amendment.
The case resulted in a unanimous decision in favor of Gideon, which forced the Supreme Court of Florida to allow Gideon a retrial. Gideon, in turn, was given a retrial with W. Fred Turner as his lawyer. Turner, during the trial, picked apart the testimony of eyewitness Henry Cook, and in his opening and closing statement suggested that Cook had likely been a lookout for a group of young men who broke in to steal beer, then grabbed the coins while they were at it. Turner also got a statement from the cab driver who took Gideon from Bay Harbor, Florida, to a bar in Panama City, Florida, stating that Gideon was carrying neither wine, beer, nor coke when he picked him up, even though Cook testified that he watched Gideon walk from the pool hall to the phone, then wait for a cab. This testimony completely discredited Cook. The jury acquitted Gideon after 1 hour of deliberation. Gideon v. Wainwright helped to redefine stare decisis, when it should be upheld and what standards should case decisions be tested against precedent to achieve a legitimacy in the eyes of the Supreme Court and lower courts.
It set grounds for Brewer v. Williams, which ruled that once adversary proceedings have begun against the defendant, he has a right to legal representation when the government interrogates him.
If an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell to write a letter to the Supreme Court, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and the whole course of American legal history has been changed. Robert F. Kennedy.